Today, I will provide a brief synopsis on the topic of the sale of securities under Regulation D, which is an important topic for many small businesses and particularly startups. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the law firm Cummings and Cummings Law. I also teach business law, including securities law, at the university level, and I hold 4 degrees, including 2 law degrees, together with a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law. Regulation D, a provision under the Securities Act of 1933, which is enforced by the Federal Securities Exchange Commission, provides certain exemptions that allow companies to offer and sell their securities without registering with the Securities Exchange Commission, or SEC. This regulation is particularly beneficial for small and medium-sized enterprises and startups, particularly seeking to raise capital from investors. However, navigating the intricacies and nuances of Regulation D can be daunting due to its complex legal and financial requirements. Often misunderstood by laypersons, including many of my students, Regulation D is not a single exemption, but rather a set of rules that encompasses Rules 504, 505, and 506. Each rule has distinct conditions and limitations, making it all the more crucial for companies to fully understand which rule best suits their unique requirements. Engaging an experienced securities law attorney and CPA can significantly aid in deciphering these complexities and ensuring compliance with federal and state securities laws. First, let's talk about Rule 504. Rule 504 of Regulation D allows companies to raise up to 10 million US dollars within a 12-month period. The rule is particularly attractive for startups and small businesses due to its relatively straightforward requirements. However, it is essential to note that Rule 504 is not available to companies that are already publicly reporting or are classified as investment companies. Despite its simplicity, Rule 504 has limitations that must be strenuously observed and considered. For instance, general solicitation and advertising are strictly prohibited unless the offering is registered in a state that requires a publicly filed registration statement and, not or, and delivery of a substantive disclosure statement to potential investors. Understanding these nuances is critical to avoid inadvertent violations, of which rescission is a potential remedy, which further underscores the importance of consulting with a knowledgeable attorney and CPA. Moving right along to Rule 506B. Rule 506B is one of the most commonly used exemptions under Regulation D, allowing companies to raise an unlimited amount of capital. This rule permits sales to an unlimited number of accredited investors, which is a very important point worthy of its own presentation, and up to 35 non-accredited investors, provided, however, they meet certain sophistication requirements. However, companies must still refrain from general solicitation and advertising under this rule. One common misconception is that Rule 506B offerings are informal and require minimal documentation. That is a total falsehood. In reality, ensuring compliance involves meticulous record keeping and the preparation of detailed disclosure documents. These documents must adequately inform investors about the investment's risks and the company's financial condition. Thus, engaging an experienced attorney and CPA to draft and review these documents is of paramount importance to safeguard against potential future costly legal challenges. Rule 506C was introduced as part of the Jobs Act and allows issuers to engage in general solicitation and advertising under like the other two rules we just discussed, provided all purchasers are accredited investors. Again, that is a very important term of art. This rule offers greater flexibility in reaching potential investors, but carries with it increased verification requirements to confirm the accredited status of those investors. Many issuers underestimate the rigor involved in verifying an investor's accredited status under Rule 506C. Simply relying on vague assurances or self-certification is woefully insufficient. Rather, issuers must take reasonable and meaningful steps to verify that status, which may include, among other things, reviewing tax returns, bank statements, or obtaining written confirmations from other financial professionals. An attorney and CPA can provide invaluable guidance in establishing a compliant and repeatable verification process, thus mitigating the risk of regulatory scrutiny and the dreaded right of rescission. Let's talk about filing requirements on Form D for just a moment. Regardless of the specific exemption utilized under Regulation D, issuers are required to file a Form D with the SEC within 15 days of the first sale of securities. This is a strict deadline. This filing is a notice rather than a registration statement and includes basic information about the issuer and the offering. Failure to timely file Form D can have serious and lasting consequences, including the loss of the exemption altogether and very significant penalties. Moreover, some states require additional filings or fees in addition to and above and beyond the federal registration, adding another layer of complexity. An attorney and CPA can assist in ensuring that all necessary filings are completed accurately and promptly, thereby preserving the exemption's many benefits. Let's briefly talk about state blue sky laws and navigating these additional requirements. In addition to federal securities laws, issuers must also consider state securities regulations, commonly known as blue sky laws. These laws vary significantly from state to state and can impose additional filing requirements or restrictions on the offering. Understanding and complying with these state-specific regimes is a complex task that often requires, I would say, pretty much always requires professional guidance. An attorney and CPA familiar with both federal and state securities laws can provide essential guidance, helping issuers navigate these regulatory hurdles and avoiding costly compliance mistakes. One of the most pervasive misconceptions about Regulation D offerings is that they are informal, simple, and require minimal oversight. In reality, these offerings are subject to stringent legal and financial scrutiny. Missteps in compliance can lead to severe penalties, including the potential for rescission or the civil liability aspect, which is potentially separate and in addition to that right of rescission. Another common pitfall is the assumption that all investors are equally sophisticated and fully understand the risks involved. This is particularly problematic when dealing with non-accredited investors under Rule 506B. Providing comprehensive disclosure and ensuring investor understanding in fact, as opposed to merely in appearance, is not only a legal obligation, but also a continuing best practice for fostering transparency and investor trust. Engaging an experienced attorney and CPA can help issuers avoid these pitfalls by ensuring that all aspects of the offering are conducted in compliance with applicable law. Navigating the sale of securities under Regulation D is a complex process that requires a thorough understanding of both federal and state securities laws. The involvement of an experienced professional at the outset and before any documents are signed or any solicitation or advertising is performed is invaluable in ensuring compliance and avoiding costly legal missteps. Professional guidance can aid in structuring the offering, preparing the necessary materials and documentation, and ensuring that all state and federal regulatory requirements are consistently met and that those requirements have been documented and addressed appropriately. By leveraging the expertise of legal and financial professionals, issuers can instead focus on their core business activities while minimizing the significant risks associated with securities offerings. The sale of securities under Regulation D offers significant advantages for companies seeking to raise capital without the burdens of full SEC registration. However, the nuances involved necessitate careful, advanced planning and professional guidance. By understanding the nuances of each exemption and adhering to all applicable regulatory requirements, issuers can successfully navigate the Regulation D minefields. Ultimately, the involvement of an attorney and a CPA at the beginning of the process is not merely advisable, but indispensable for ensuring compliance and protecting the interests of both the issuer and the investors alike. With the right professional support, companies can confidently pursue their capital raising objectives while mitigating the risks and burdens associated with securities offerings. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this presentation is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding the content of this presentation or of any of my earlier talks, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.